Well, all my respected and learned brothers and sisters, this is Advocate P. Devmorari talking to you from Ahmedabad city, Gujarat state, India, that is our Bharat. Today I have selected a very interesting and useful topic to all the people. And from Civil Procedure Code, that is Order 39, Rule 1, temporary injunctions. Rule 1, cases in which temporary injunction may be granted. If this topic is useful all over India, in all the courts of India. A person who seeks temporary injunction must satisfy the court as to the existence of these three important conditions which govern the exercise of discretion conferred by the Rule 1 of Order 39 of CPC. Number one, there must be a prima facie case. Number one, irreparable injury. Number three, balance of convenience. It is well established legal principle that the prima facie case, balance of convenience, and irreparable injury should be examined independently. Findings regarding it need not be interdependent. In other words, all the three ingredients must coexist before relief is granted. Mere proof of any one of three conditions do not entitle a petitioner to an order of temporary injunctions. Citation, year 2002, Gujarat 368. Injunction cannot be granted in favor of a person who indulges in suppression of material facts. Citation, 1996 AISC 3132. Now let us dive into the meaning of a prima facie case. What do we mean by prima facie case? The conditions to the effect that there is a serious question to be tried in the suit and of the facts before the court. There is a probability of the applicants being entitled to the relief asked for by him is generally termed as prima facie case. In other words, the prima facie existence of right and infringement are the first condition for the grant of temporary injunctions. Claim for relief of permanent injunction is not a precondition for a grant of temporary injunctions. Temporary injunction can be granted if conditions mentioned in clauses A, B, C of Rule 1 of Order 39 of CPC exist jointly or severally. Year 1992, Rajasthan 29. Prima facie case means the existing circumstances justifying the trial of question of facts and law raised in the litigation. Merely filing a suit does not show existence of prima facie case. There has to be facts and law, question of facts and question of law. In absence of these two, that suit cannot be entitled for temporary injunctions. Prima facie is not to be confused with prima facie title, which has to be established by evidence, but if only means a substantial question raised bona fide, which at first sight needs investigation and decision. For grant of temporary injunctions, it is not necessary for plaintiff to establish his full-fledged title over suit property. Now, this is very important legal point, please remember. Prima facie title holder of the should properties, temporary injunctions can be granted in his favor. 1988, in bracket, 4 Bombay CR 270. The applicant should, besides showing existence of prima facie case, for the satisfied that the court's interference is necessary before his right can be established on trial by showing that irreparable injury will accrue to him if the injunction is not granted. Year 1976, Patna 326. Year 1990, SC 867. This is also a very important point now. Unless defendant's prima facie case outweighs prima facie case of plaintiff, I repeat, unless defendant's prima facie case outweighs prima facie case of plaintiff, it cannot be said that plaintiff has failed altogether to make out a prima facie case. Prima facie case means a case which cannot be thrown out on technicality, such as the shoot by limitation or the like. The shoot cannot be thrown out on technical grounds as not maintainable, and if the shoot is such that the disputed question of facts and law are involved, no doubt they are required to be determined and answered after recording the evidence that it may be said to be a prima facie case. Such case has got prima facie case. 1999 AISC 1870. When serious issue of deception is involved, injunction can be granted in favor of plaintiff if there is deception. Plaintiff failed to make out a prima facie case in his favor, then question of balance of convenience or irreparable injury does not arise. It should be thrown out. He is not entitled for temporary injunctions. Now let us see principle of balance of convenience. The condition about the existence of which the applicant has to satisfy the court, and which is to be effect that the mischief likely to issue from withholding the injunction will be greater than that like to arise from granting. It is called the principle of the balance of convenience. I'll repeat, I emphasize on this. The conditions about the existence of which the applicant has to satisfy the court, and which is to the effect that the mischief likely to issue from withholding the injunction will be greater than that likely to arise from granting. It is called the principle of balance of convenience. Citation, year 1978, Gujarat 13. Year 1978, Delhi 174. Year 1983, SC 742. Word injury in Rule 1 of Order 39 means any wrong or damage done to another, either in his person, rights, reputation, or damages, irrespective of how harm or damage may arise. Now, irreparable injury. The term irreparable injury means that the injury must be a material one that cannot be adequately compensated for damages. Claimant cannot be adequately compensated if he ultimately succeeds in his suit. The applicant for injunction must show that there is no other remedy open to him by which he can protect himself from the consequences of the apprehended injury. Year 1976, SC 2621. There has to be a substantive right which requires protection, and in such a case, injunction can be granted. If you have got substantive right then injunction can be granted. The irreparable injury flows from the prima facie case and balance of convenience and inconvenience. But when there is no legal enforceable right, then it becomes idle parade for a litigant to canvass his case, his cause. The petitioner cannot enforce his right in a proceeding in violation of statutory provision. He must have legal enforceable right. An injunction can be granted under Rule 1 of Order 39 of CPC if there is real danger of the subject matter of the suit being wasted or damaged or alienated by any party to the suit. Yeah, 1928 Patna 111. Where there is no allegation of danger of such waste or damage, the application should be rejected. Yeah, 1967 Tripura 38. The most important point is genuineness of document cannot be gone into the proceeding under Order 39 Rule 1 and 2. Year 1998, Punjab, Haryana 230. Now I'll press into service Indian Evidence Act. Now it is Bharatiya Saksha Adhiniyam. Indian Evidence Act Section 90. Now in its place, Bharatiya Saksha Adhiniyam 2023. Evidence Act Section 90. Now BSS Section 92. It talks about presumption as to documents 30 years old. Explanation. The explanation to Section 80 shall also apply to this section. Now I'm giving you one illustration. It is very easy to understand. You cannot raise any question when document is of 30 years old. Proper document. Now illustration is, he has been in possession of landed property for a long time. He produces from his custody deeds relating to the land, showing his title to it. The custody shall be proper. So this type of document can be admitted in evidence, and opposite party, that is respondent or any party, cannot raise any question or any doubt on that. So if he has got title like this, then he can get temporary injunction without any hesitation. That's all in this video. Thank you very much for joining us and for patient hearing. If you are new to our video, please subscribe it, like it, and share it. If you are not new, if you have not yet subscribed, please be cooperative to subscribe it, like it, and share it. This is useful to all. See you in the next video with a very interesting topic. See you in the next video. Thank you very much. Thank you, thank you, thank you.